This is the brief on the legal boundaries of your identity and authority. You see, Philippine law is literally obsessed with making sure you are exactly who you say you are, handing out steep penalties to anyone hiding their identity or faking authority. First, let's talk about your name. Under the rule of the christened name, you gotta use your childhood name. Think of your legal name as your phone's factory hardware and an alias as a third-party app. You can't just install it for official use without court permission. Casual artistic pen names are totally fine, but even with an authorized alias, you still gotta disclose your real name. Second, let's look at criminally hiding your identity. Publicly using a fictitious name to cover up a crime lands you a 100,000 peso fine and up to 6 months in jail. Just concealing true name, that's a 40,000 peso fine. But get this, what if you sign a fake name on a private bank document? Surprisingly, thanks to the Estrada case, it's not a crime. Private bank records lack that required public deception element. Finally, stealing someone's authority is a whole different ballgame. Usurpation of authority means doing official government acts without actual entitlement. Also, publicly wearing police or military gear is absolutely illegal. Under the colorable resemblance rule, fakes don't even need to be perfect. Like a bootleg designer bag, if it's close enough to fool average people, it's illegal, unless it's just a movie costume. Ultimately, whether it's the signature on a document or the uniform on your back, the law demands you represent exactly who you are, with no deceptive replicas allowed.
Welcome to this video on Falsities and Deceit, the Architecture of Impersonation. We will break down Articles 177, 178, and 179 of the Revised Penal Code, focusing on the legal framework surrounding usurpation and false identity. These crimes are offenses against public interest. They include usurpation, falsified identity, and illegal uniforms. The core insight is that all three damage public trust through the unauthorized assumption of an identity, rank, or name. Article 177, usurpation, has two forms: usurpation of authority, which is falsely representing oneself as an officer or agent, and usurpation of official functions, which is performing an official act without lawful entitlement. For usurpation of authority, the representation must be positive and explicit, demonstrated by overt acts, and the agency must be a real government entity. This applies to public officers, but not to an occupant acting under color of title. Usurpation of official functions requires the pretense of official position, performance of the act, and lack of lawful entitlement. Note that mere pretense without action is insufficient. RA number 10 is an emergency measure with limited application, restricting its use to subversive organizations. Article 178 covers using a fictitious name, which is actively using a fake name publicly without authority, and concealing true name, which is passively hiding one's real name. The crucial distinction between the two is publicity and purpose. Using a fictitious name requires two elements: public use of the name and a specific purpose to conceal a crime, evade execution of judgment, or cause damage to public interest. If the intent is to cause damage to private interest, it falls under estafa, not Article 178. The privacy exception, established in People v. Estrada, clarifies that signing a trust account with an alias is not considered public use because RA No. 1405 protects the secrecy and private nature of bank transactions. Concealing true identity involves hiding one's real name and personal circumstances, with the singular purpose of identity concealment. Unlike using a fictitious name, publicity is not required for this crime. Legal aliases are permitted for entertainment and sports. Judicial authorization makes the use of a substitute name valid. However, officially, only names properly recorded in the civil registry may be used. Article 179 penalizes the illegal use of uniforms and insignia, which involves publicly and improperly wearing attire pertaining to an office or class of persons the individual is not a member of. The penalty is arresto mayor. The threshold of deception ranges from imaginary uniforms, which are safe, to exact imitations, which are guilty. The legal threshold is colorable resemblance, an outfit calculated to deceive the common run of people. Special laws apply to uniforms and insignia. RA 75 on foreign states requires intent to deceive or defraud. RA 493 on armed forces and PNP punishes illegal wearing of rank, but exempts use in theatrical productions. This diagnostic matrix summarizes the requirements. Article 177 and concealing identity under Article 178 do not require publicity, while active use of a fictitious name and illegal use of uniform do. Specific intent is crucial for all crimes, except the default under Articles 177 and 179. The penalty scale reflects the threat to public interest. Usurpation of authority or functions is the highest threat, while concealing a true name is the lowest. The Revised Penal Code punishes the active usurpation of state authority more severely.
What have a fake cop, a secret bank account, and a Halloween costume all got in common? Well, in the Philippines, they can actually land you in jail. Today, we're going to explore that super fine line between a harmless little fib and a serious felony.
So, where exactly does the law draw that line? To figure it out, we're going to dive into 3 key articles in the Revised Penal Code. All of them deal with falsities, and each one comes with some pretty surprising real-world examples that really push these laws to their limits.
First up, let's take a look at Article 177. This is all about what happens when somebody pretends to have power or authority that, well, they just don't have.
Okay, so get this. This scenario comes straight from a real court case, People versus Reyes. I want you to picture it. You've got this guy with nothing but a whistle and a whole lot of confidence, and he just starts directing traffic like he's a cop. He's blowing the whistle, he's stopping buses, he's even demanding to see licenses. All of it was just part of this act he was putting on.
And this is where it gets really, really interesting. See, he never wrote a single ticket. He didn't arrest anybody. He just played the part. So the big question is, did he actually commit a crime? The answer to that question reveals a super important legal distinction.
What's so cool about this is how it breaks down Article 177 into 2 totally separate offenses. Think of it like this. Usurpation of authority is like claiming you're a 5-star chef without ever cooking a single meal. Just saying it is the crime. But usurpation of official functions is like actually going into a restaurant kitchen and cooking a meal pretending you're the chef. You have to actually do the thing. For our guy with the whistle, just pretending to be a cop? Yep, that was enough.
And you know, it's not just random people who can get into trouble for this. In one case, People versus Hilvano, a town councilor was the acting mayor. But when the vice mayor, the person legally supposed to take over, was ready, the councilor refused to step aside. The court found him guilty of usurping the mayor's authority. It just goes to show you can't hold on to power that isn't rightfully yours.
Okay, so let's shift gears now. We've gone from faking power to faking an identity. And that brings us to Article 178, which is all about, you guessed it, what's in a name.
Now, the law defines a fictitious name as any name that's used publicly without legal authority. But here's the kicker. Just using a fake name isn't automatically a crime. The courts have a very specific checklist they use to decide if it actually crosses that line.
To be found guilty under this law, the prosecution has to prove 3 things. 1, you used a fake name. 2, you used it publicly. And 3, you did it for a bad reason, like to hide a crime, dodge a court order, or just cause some kind of damage. If they can't prove all 3 of those things, the whole case just falls apart.
And this brings us to one of the most famous tests of this law ever, the case against former President Joseph Estrada. He signed documents to open a secret bank account under the name Jose Velarde. Now, on the surface, that seems like a total slam dunk, right? He used a fake name. But the entire legal battle came down to that second element. Was the act done publicly?
And this is where the court's logic is absolutely fascinating. The Supreme Court ruled that because of the secrecy of bank deposits law, signing private bank documents, even with other people in the room, happened inside a zone of privacy. So it didn't meet that crucial requirement of public use. It's just this wild example of how one law can basically act as a shield against another one. So Article 178 also punishes a second, related crime, concealing your true name. And the key difference, as you can see right here, is all about publicity. Think of it this way. Using a fake name to get a bogus loan? That's a public act with a bad intention. But just hiding your real name so someone can't find you? That's a private act of concealment. See the difference?
All right, we've covered faking power and faking names. Let's talk about appearances. What happens when it's not your authority you're faking, but just your outfit? That brings us to Article 179, which is all about the illegal use of uniforms and insignia. And hey, just like with fake names, there's a specific checklist for when a costume becomes a crime. You have to wear it publicly and improperly, but here's the crucial part. It has to be the uniform of a real existing office or group. And obviously, you can't actually be a member of that group. Now, you might be thinking you need a perfect movie-quality replica to get into trouble, but nope.
The law uses this phrase, colorable resemblance, which is just a fancy way of saying if the uniform is close enough to fool a regular person on the street, it's close enough to be illegal. But here's a fascinating little twist that comes from that legal checklist. Remember that part about the office having to be real? Well, that means you can't be prosecuted for wearing the uniform of a fictional organization. So, in an actual case, someone dressed up as an officer of the Philippine Board of Safety. They weren't found guilty under this law because, well, that board was just a private company, not a real public office. The law only cares if you're impersonating actual authority.
So we've looked at faking power, faking names, and faking uniforms. What's the one big thing to take away from all of this? It's that in the eyes of the law, context and intent, they're absolutely everything.
This little summary cable really puts it all together nicely. For usurping authority, the crime is just in the act of pretending itself. For using a fake name, the prosecution has to prove it was done publicly and for a bad reason. And for wearing an illegal uniform, the key detail is that the uniform has to belong to a real organization. 3 very similar ideas, but with 3 very different legal lines drawn in the sand. And that leaves us with this final, really urgent question for the world we live in now. I mean, these laws were written long before the internet even existed, so how are they going to hold up? When someone uses a fake online profile to cause damage, is that public use? Could a deepfake video be considered a new kind of illegal uniform? The line between lies and law is being redrawn as we speak, and honestly, only time will tell where it's all going to end up.
Imagine for a moment that you're just walking into a local bank to open a standard savings account.
Right, something we all do.
Exactly. Or, maybe you're sitting across from a landlord getting ready to sign a new lease for an apartment.
Yeah.
So the person slides the paperwork across the desk, you pick up a pen, and you write down your name. Mm-hmm. The name you've used since childhood.
Yeah.
Like the name your friends call you. And when you do that, you probably feel this profound sense of ownership.
Oh, absolutely.
You think, this is who I am. I own this combination of letters.
Yeah.
But, well, the reality of the legal landscape is far more complicated.
Yeah, way more complicated.
Because you don't actually own your identity. What you possess is essentially a license.
Right.
A highly specific, heavily monitored license granted to you by the state. And the rules governing how, when, and where you are legally permitted to use that identity are, they're astonishingly strict.
They really are. And it's a reality that most people never truly confront until they accidentally bump into the edges of the law,
Yeah, usually when it's too late.
Exactly. There is this constant invisible tension between the person you see in the mirror, like the organic, evolving human being, and the static person recorded on the state's legal ledger.
And exploring that exact tension is our mission for this deep dive. Today, we're immersing ourselves in the really intricate architecture of Philippine laws surrounding identity.
It's a fascinating web.
It is. We're looking at the legal boundaries of using aliases and the severe consequences of usurping authority. And we have a really great stack of legal sources to pull from today.
We do. We're going to examine the bedrock rules set down in Commonwealth Act No. 142.
Right.
And we'll explore the Penal Code's approach to fake personas, specifically Articles 177 through 179.
And ultimately, we're going to see all of these laws collide in this monumental 2009 Supreme Court decision.
Oh, that case is incredible.
It really is. It involves a former president of the Republic, a highly controversial bank account, and an alias that completely shook the country.
But, from anyone listening, I think it's crucial to understand that this isn't just abstract legal theory.
No, not at all.
Every single time you execute a legal document, every time you create a profile, or, even when you decide to go by a nickname professionally, you are interacting with this complex legal web.
You're right in the middle of it.
Exactly. The state is perpetually trying to balance your fundamental human right to privacy against society's really desperate foundational need for transparency and order.
And accountability.
Exactly. Accountability.
So to really grasp how deep this goes, I think we have to start at the bedrock.
Let's do it.
The foundation of Philippine identity law is Commonwealth Act No. 142. And looking at the date here, this act was passed in November of 1936.
Yeah, it's an old one.
Almost a century old. Yet it still dictates the baseline rules of who you are legally allowed to be.
Right.
Section 1 lays down a rule so ironclad, it honestly feels a bit jarring in the modern world. It mandates that no person shall use any name different from the one with which they were christened.
Or by which they've been known since childhood.
Right. It even dictates the structure like, Your name must comprise the patronymic name, your father's family name, and one or two surnames.
It leaves absolutely zero room for the fluid reinvention of identity that, we often take for granted today.
Oh, none whatsoever.
The state is essentially demanding a permanent, traceable linguistic tag.
And the exceptions they carved out back in 1936 are just incredibly narrow.
Very specific.
Yeah, the law states you can use a pseudonym, but strictly for literary purposes, cinema, television, radio, or other entertainment.
Right, like a stage name.
Exactly.
Right.
They also allow it in athletic events where a pseudonym is a normally accepted practice.
Like a boxer's ring name.
Yeah. But if you aren't writing a novel or acting in a film or stepping into a boxing ring, the state unequivocally demands your original recorded name.
And if you fall outside those very specific entertainment exceptions, the bureaucratic hoops you have to jump through just to legally use an alias are, well, they're staggering.
I was reading sections 2 and 3 of CA 142, and it reads like a labyrinth.
It really does. You cannot simply make a personal decision to change what you are called. You have to actively petition the judicial system.
You have to go to court.
You do. You must initiate formal proceedings in court, identically to the process required for a total legal name change.
Which means hiring a lawyer, paying filing fees, and, just waiting for court dockets to clear.
Exactly. And the petition itself must be meticulously detailed. You have to lay out your baptismal name, your family name, the name as it appears in the civil registry.
Wow, they want everything.
Oh, yeah. And your immigrant's name, if you happen to be a foreign national, plus the exact pseudonym you wish to adopt.
So you can't just say, I want a nickname.
No. But the most critical part is that you must provide the court with the specific reason why you desire this alias.
Wait, so the state gets to judge the validity of your desire for a new identity?
That's exactly right. They have to approve your reason.
Okay, well, I was reading through section 3, and I realized that even if the judge agrees with your reasons and grants your petition, you still don't get to just swap your names out.
Nope.
The law requires you to formally record this judicial authority in the local civil registry.
Mm-hmm.
But here is the part that genuinely surprised me.
The signature rule.
Yes. Once you have this legally authorized alias, you cannot execute any document using only that alias.
Right. That is a crucial safeguard built into the law.
It's wild.
Section 3 explicitly mandates that no person who has obtained judicial authority to use an alias shall sign or execute any document without stating their real name and all aliases they have been authorized to use.
So it's not a replacement at all. It's an addition.
Precisely.
Like, if my legal name is John Doe and I go through this whole expensive court process to legally use the alias Jack Smith, I can't just sign a contract as Jack Smith.
No, you cannot.
I have to sign it as John Doe, also known as Jack Smith.
Exactly. The state's primary objective here is to maintain an unbroken paper trail.
They don't want you disappearing.
Right. They want to ensure that your physical person is permanently tied to a single continuous record of legal and financial obligations.
Makes sense.
You cannot use an authorized alias to escape the history of your original name. And the state enforces this with real teeth.
Yeah, Section 4 dictates the penalty for violating this act. It's imprisonment ranging from 1 month to 6 months.
For a name.
Just for a name. When I try to conceptualize this, my mind immediately goes to the digital world.
Oh, that's an interesting comparison.
It feels very much like a strict verification badge on a social media platform, but applied to physical life.
Yeah, the little blue check mark.
Exactly. On those platforms, if you have a verified account to prove your identity and you suddenly change your display name drastically, the system flags you.
You might lose the badge.
Right, or the algorithm might suspend you for impersonation because it breaks the chain of trust.
That's a perfect analogy.
Commonwealth Act 142 is doing the exact same thing, but with ink and paper.
Yeah, it is.
But honestly, looking at it from a modern perspective, threatening someone with half a year in jail just for using an unauthorized nickname seems like massive legislative overkill.
It sounds draconian now, for sure.
Yeah, why was the state so, uncompromising about this in 1936?
Well, to understand the severity of the law, you really have to transport yourself back to the economic realities of Manila in the 1930s.
Okay, set the scene for me.
So the sources, specifically the historical context provided in the Ursua case, which we'll definitely unpack in great detail later, explain that this law was not passed to punish people for having casual nicknames.
It wasn't about what your friends called you.
No, not at all. It was enacted to combat a very specific, systemic, socioeconomic crisis.
What kind of crisis?
During that era, there was a widespread practice among certain groups of Chinese immigrants of adopting scores of different names and aliases for trade purposes.
Oh, I saw that. The text mentions individuals claiming to possess 1,001 names, which sounds completely hyperbolic, but clearly the legislature saw it as a massive epidemic.
It was an epidemic of financial untraceability. You have to envision a rapidly developing mercantile economy.
Lots of trading, lots of merchants.
Exactly. And everything relies on trust, reputation, and the ability to enforce contracts.
Right.
So imagine a merchant who borrows money or accepts a massive shipment of goods under the name Merchant A.
Okay.
When the debt comes due, Merchant A vanishes into thin air.
Just gone.
Gone. And the very next day, the exact same physical person opens a new storefront across the street, operating under the name Merchant B, claiming absolutely no relation to the debts of Merchant A.
Wow. That would completely paralyze the credit system.
Completely.
I mean, if suppliers can't track who owes them money, commerce just stops.
Exactly. It borders on outright fraud, but the authorities at the time found it incredibly difficult to prosecute under existing laws.
Why was it hard to prosecute?
Because the individuals could simply argue that these weren't deceptive aliases. They'd claim they were merely cultural or regional variations of their identity.
Loophole.
A huge loophole. The state realized that if they couldn't securely tie a single physical body to a single legal identity, the entire economy was vulnerable to just chaotic unpredictability.
So they brought the hammer down.
They deployed a sledgehammer. Commonwealth Act 142 wasn't concerned with social clubs. It was designed to ensure that if you signed a promissory note, the state knew exactly who you were.
And you could never legally hide behind a different signature.
Precisely.
Okay, that context changes everything. It's not about policing personal expression. It's about protecting the integrity of the marketplace.
Exactly.
But, the legal framework doesn't stop at regulating trade aliases.
No, it goes much further.
The sources guide us from Commonwealth Act 142 right into the Revised Penal Code. Specifically, Article 178, which deals with identity manipulation that crosses the line into active, malicious deception.
Yes, and the code actually splits this kind of identity falsification into two very distinct crimes.
Right, and the dividing line between those two crimes is entirely about the offender's intent and the level of public deception, isn't it?
That's the crux of it. Article 178 categorizes the offenses into using a fictitious name and concealing true name.
Let's look closely at the first one, using a fictitious name.
Okay.
The jurisprudence, like that foundational case of U.S. versus Talipai, establishes very strict parameters.
Yes, it defines a fictitious name as any name publicly applied by an offender without the authority of law.
But merely using the name isn't the crime itself, right?
Right. The law requires a specific nefarious purpose.
The sources actually list 3 specific purposes required to trigger this severe charge.
Let's hear them.
You have to use the fake name publicly, either to conceal a crime, to evade the execution of judgment, or to cause damage to public interest.
Let's break those down because the distinctions really matter here.
Okay, concealing a crime seems pretty straightforward.
It is. If someone commits a bank robbery and then registers at a hotel under a completely fabricated identity to evade the ensuing police manhunt.
They're actively using a fictitious name to conceal their crime.
Exactly. Now, evading the execution of a judgment is similarly deceptive, but it's usually financial.
Like trying to get out of paying up.
Right. If a court orders you to pay millions in damages and you begin operating all your public affairs under a newly invented name to hide your assets from the sheriff, you are violating this article.
Got it. Now, the third category is the one that really caught my eye. To cause damage to public interest.
Ah, yes.
The sources are very careful to distinguish this from damaging a private interest.
That's a crucial difference.
Like if I invent a fake name solely to trick one specific person into giving me their life savings, I'm committing estafa, right? Which is fraud.
Yes, exactly.
But how does the law define damaging the public interest with a name?
That brings us directly back to the U.S. versus Talipai case you mentioned.
Oh.
In that ruling, the Supreme Court explicitly stated that using a fictitious name in an application for a passport constitutes a public use that damages the public interest.
A passport. That makes total sense.
Think about the mechanics of a passport. It is the ultimate document of state trust.
It really is.
By injecting a fake identity into the state's official diplomatic records, you aren't just cheating one person, you are compromising the integrity of the entire national registry.
You're damaging the state's ability to verify its citizens to the rest of the world.
Precisely. And because that strikes at the core of the state's authority, the penalty is severe.
I noticed that. The sources note that following the amendments by Republic Act No. 10951, the penalty for using a fictitious name is arresto mayor and a fine not to exceed 100,000 pesos.
It's a heavy hit.
And just for the sake of clarity, because legal terminology can be pretty dense, let's define arresto mayor.
Good idea.
Under the Spanish-derived Philippine penal system, penalties are bracketed into very specific timeframes. Arresto mayor signifies imprisonment ranging from 1 month and 1 day up to a maximum of 6 months.
So you're looking at up to half a year in a penal facility.
Plus a very substantial fine. It really reflects the gravity of actively deceiving the public machinery.
Now, compare that severity to the second offense under Article 178, concealing true name.
Okay, how does that one differ?
The elements here shift dramatically. For this crime, the element of publicity is entirely removed.
Oh, so you don't have to be public about it.
Right. The offender doesn't need to be publicly broadcasting a fake persona. The law merely requires that a person conceals their true name or personal circumstances, and their sole purpose is simply the concealment of their identity.
Wait, so if they aren't hiding from a robbery charge and they aren't dodging a lawsuit, they just want to remain invisible? Why is that still a crime?
Because the state still maintains its baseline demand for transparency.
It comes back to that ledger.
Exactly. Even without malicious intent to defraud the government or escape justice, the act of intentionally masking your identity disrupts the societal order.
They just don't like secrets.
Pretty much.
Well,
However, the law does recognize the difference in scale here.
right.
Hiding in the shadows is not as destructive as actively parading a fraudulent persona in the public square. Therefore, the penalty drops significantly.
How much does it drop?
Concealing true name is punishable by arresto menor or a fine up to 40,000 pesos.
And again, just translating the jargon here, arresto menor is the lowest tier of incarceration in the penal code, ranging from just 1 day to a maximum of 30 days.
Exactly. The code is meticulously calibrating its punitive response.
So it fits the crime.
Right. If your goal is simply to be sneaky and hide, it's a misdemeanor level offense. You might spend a few weeks in detention.
But if you construct a whole new identity to actively cheat the system and subvert public records,
Then the state brings down a much heavier hammer.
which leads us perfectly into the next layer of this legal ecosystem. We've spent all this time dissecting how fiercely the state protects the letters that make up your name.
The label of your identity.
Exactly, the label. But society doesn't just interact with your label, it interacts with your function.
Your authority.
Yes, and if the laws are this unyielding about you changing your name, the state's reaction to you faking your role in society is on an entirely different level.
Oh, a completely different level.
This brings us to Articles 177 and 179, the usurpation of authority and the illegal use of uniforms.
We are crossing the boundary from stealing a name to stealing state power.
That sounds intense.
It is.
Yeah.
Article 177 is titled Usurpation of Authority or Official Functions. And much like the previous article, it elegantly splits the concept of faking a role into two distinct criminal acts.
Okay, let's look at the first one, the usurpation of authority itself.
The mechanics of this are fascinating.
They really are. The law states this occurs when a person knowingly and falsely represents themselves to be an officer, agent, or representative of any department or agency of the Philippine government.
Or of a foreign government, too.
Right. But what really jumped out at me in the sources is that the crime is complete upon the mere representation.
Yes, that is the critical nuance. To be guilty of usurpation of authority, the performance of an actual official act is not strictly required.
So you don't even have to do anything official.
Nope. The crime crystallizes the moment you explicitly, positively, and falsely claim to be vested with state power.
Wow.
But the jurisprudence demands that this representation must be overt and undeniable. The state cannot prosecute you simply because someone assumed you were a government agent due to your demeanor.
You actually have to assert the authority.
Yes, you have to claim it.
There is a case cited in the materials that paints a vivid picture of what this looks like in practice. People versus Reyes.
Oh, that's a cornerstone example.
The details of this case perfectly illustrate how an overt act constitutes false representation.
They really do. In this case, the accused didn't just walk around telling people he was a police officer. He took aggressive physical control of a public space.
What did he do?
Well, the court established his culpability because he engaged in a highly specific sequence of actions. He stood in the street, blew a police whistle to halt traffic, forced commercial buses to stop, and then ordered the drivers to step down and produce their licenses.
Okay, so he wasn't just wearing the label of a cop. He was wielding the mechanism of the state.
Exactly.
He was taking the sovereign power to regulate civilian movement and applying it illegally.
Precisely. He hijacked the psychological deference that citizens are conditioned to give to law enforcement.
Because when you hear that whistle,
Right. When a citizen hears that whistle and sees a person commanding traffic, they submit to the authority of the state.
instinctively.
By falsely assuming that role, Reyes didn't just trick the bus drivers, he assaulted the very trust that allows a society to function.
But the sources don't just focus on private citizens pretending to be cops. There's another case here, People versus Hilvano, which introduces a twist I didn't see coming at all.
The city councilor case.
Yeah. It proves that you don't have to be a fraudster off the street to be guilty of usurpation. An actual elected public official can be guilty of usurping authority.
It's a great twist.
How does the law conceptualize that?
It requires looking at the strict boundaries of municipal law. In the Hilvano case, the accused was a legitimate sitting city councilor.
So he already had power.
Yes. Because the city mayor was temporarily absent, this councilor was designated to discharge the mayoral duties.
Okay.
Up to that point, everything was completely legal. He was exercising authority that was properly delegated to him.
Right, just filling in.
However, the law governing municipal succession was very clear. In the event of the mayor's temporary absence, the legal right to step into that office actually belonged to the vice mayor.
So the councilor was just a placeholder until the vice mayor arrived.
Exactly, and the moment of usurpation occurred when the legal reality caught up with the situation.
When did that happen?
The councilor was officially informed of the law. He was told, the vice mayor is here, the law dictates he takes over, your temporary mandate has expired.
And he refused to vacate the office.
He dug in his heels. By clinging to the physical office and continuing to exercise the executive powers of the mayor after being formally legally notified that he possessed absolutely no legal right to do so.
His status instantly transformed.
Yes. He went from being a legitimate temporary executive to a criminal usurper.
Wow.
Article 177 is blind to whether you are a private citizen or a politician. It simply asks, are you exercising state authority that you do not legally own?
But the law can't just be a trap for government officials who make honest administrative errors, right?
No, it isn't.
Because the sources outline this massive legal shield known as the color of title. And the case of People versus Buenaflor defines this. I really want to break this down because it seems fundamental to how governments transition peacefully.
It is fundamental. Color of title is a vital legal doctrine designed to protect the stability of public administration.
How does it work?
In Buenaflor, the court ruled that Article 177 is designed to punish the malicious usurper, the person acting under deliberate false pretenses. It explicitly does not apply to a person who occupies an office under a color of title.
Okay, let's build a scenario to really understand the mechanics of this.
Well, let's do it.
Let's say we have a fiercely contested local election for town mayor. The votes are counted, it's incredibly close, but the Electoral Commission declares candidate A the winner.
Happens all the time.
Right. So candidate A takes the oath, sits at the mayor's desk, and starts signing city ordinances and directing the police force.
Standard procedure.
Meanwhile, candidate B files a massive electoral protest, claiming the ballots were miscounted.
A very common scenario in local politics.
Exactly. So 6 months later, a higher court reviews the ballots and rules that candidate B was actually the rightful winner all along.
Yeah.
Candidate A's proclamation is annulled. Now, for those 6 months, candidate A was exercising the authority of the mayor, but technically, the court just said he never legally won the election. Under a strict reading of Article 177, was candidate A usurping authority for half a year? Should he go to prison?
Under the doctrine of color of title, absolutely not. Candidate A is fully protected.
Why is that?
Because during those 6 months, he wasn't acting under false pretenses. He possessed a certificate of proclamation from the Electoral Commission.
Ah, the paperwork.
Exactly. That document provided him with a legitimate, legally recognized claim to the office at that time, even though a court later determined that claim was flawed and overturned it.
So he thought he was the mayor.
He genuinely believed, backed by an official state document, that he held the authority.
He had the color of legitimacy.
Exactly. If the law didn't recognize color of title, no official would ever make a decision during an election dispute out of fear of being thrown in prison later.
Yeah, government would just grind to a halt.
The state requires continuity of government. The color of title doctrine ensures that officials who act in good faith under a seemingly valid claim are insulated from criminal liability, while still allowing the true winner to eventually take their rightful seat.
That perfectly explains the first half of the law. Now, what about the second half? Usurpation of official functions.
This shifts the focus from the claim of identity to the execution of the act.
How so?
Here, the offender actively performs an act pertaining to any person in authority under the pretense of official position without being lawfully entitled to do so.
Okay, so unlike mere representation, the physical performance of the official act is the core element of the crime here.
Exactly. You aren't just wearing the badge, you are writing the citation.
What's the penalty for that?
The penalty for violating Article 177, whether by usurping authority or official functions, is prison correctional in its minimum and medium periods.
And again, let's translate the penal code for a second. Prison correctional is a serious jump in severity.
A very serious jump.
We are moving out of the realm of weeks or months. This penalty ranges from 6 months and 1 day all the way up to 6 years of imprisonment.
Yeah, up to 6 years.
The state is making it crystal clear that impersonating its agents is a felony-level threat to societal stability.
And the state's paranoia about this threat is so deep that they have layered additional, highly specific laws around the penal code to cover every conceivable angle of usurpation.
The sources highlight several of these standalone Republic Acts. Let's walk through them because they really show the historical anxieties of the legislature.
Sure. First, there's Republic Act No. 75.
Right.
RA 75 extends the protection beyond the Philippine government. It imposes severe penalties, significant fines, and up to 5 years in prison specifically for usurping the authority of diplomatic or consular officials of a foreign government.
Wow, they really didn't want international incidents.
Exactly. The state recognized that allowing fraudsters to impersonate foreign diplomats could trigger massive diplomatic crises. However, this law requires a specific intent to defraud, adding a layer of required maliciousness.
Got it. Then the sources bring up Republic Act No. 10. And the date on this one is incredibly telling.
1946.
Right. It's an old law passed right in the immediate aftermath of World War II. It penalizes anyone performing acts pertaining to government officials with or without the pretense of official position.
It does.
That sounds incredibly broad.
It sounds broad on paper, but the jurisprudence has aggressively narrowed it. The Supreme Court, in a case called People v. Lidras, looked at the historical reality of 1946 Manila.
What's going on then?
The country had just been liberated from Japanese occupation. The government was shattered. Various armed groups, seditious organizations, and rebel factions were roaming the countryside, attempting to set up shadow governments and administer their own brutal justice.
It was a fight for the very existence of a unified state.
Exactly. The Supreme Court ruled that RA 10 was an emergency post-war measure designed explicitly to crush those subversive activities.
So it wasn't for regular criminals.
No, it was a tool to prosecute rebels acting as impromptu judges and executioners. Therefore, the courts generally restrict the application of RA 10 to members of seditious organizations.
Okay, that makes sense.
You wouldn't use this 1946 law to prosecute a teenager who buys a fake police badge online today. You would use the standard Article 177. The context of the law dictates its application.
Which brings us to the visual manifestation of all this authority. If the state rigorously protects the name and fiercely protects the function, it must also protect the aesthetic.
Oh, definitely.
This leads us to Article 179, the illegal use of uniforms or insignia. The law states that the penalty of arresto maior, which we established is up to 6 months in jail, shall be imposed upon any person who publicly and improperly makes use of insignia, uniforms, or dress pertaining to an office not held by such person.
Or to a class of persons of which he is not a member.
Right. What's the rationale there?
The rationale here is entirely psychological. A uniform is the most immediate, visceral language of authority. When you see a police uniform, your brain doesn't ask for a legal brief. It instinctively commands deference.
You just listen.
The state relies on that instant visual compliance to maintain order during emergencies. If the state allows its visual language to be co-opted by anyone, the monopoly on authority dissolves.
So if anyone can dress like a cop,
If anyone can legally walk down the street in a police uniform, the public trust evaporates in an instant.
Okay, I understand the theory, but I have to push back on the practical application here.
Let's play devil's advocate.
Let's look at how people actually behave.
Yeah.
Every October, thousands of people attend Halloween parties. People dress up as police officers, as doctors, as military generals.
Sure.
Does Article 179 mean that every college student in a cheap cop costume is committing a crime punishable by 6 months in prison? Are the authorities legally obligated to raid fraternity mixers?
It's a great question, and the answer lies in the meticulous wording of the statute and how the Supreme Court has interpreted it.
Okay, lay it on me.
The operative phrase in Article 179 is that the use must be publicly and improperly. Context is everything here.
So a party isn't improper.
Attending a private themed costume party is universally understood as theatrical. It is not an improper assertion of state authority. No one at a Halloween party believes the person by the punch bowl is there to execute a search warrant.
Okay, fair enough. But what if they wear it out on the street? How good does the fake uniform have to be to trigger the law? Does it have to be an exact stitch-for-stitch replica of the official issue?
The jurisprudence provides a very clear standard on this, specifically in the case of People versus Romero.
What did they decide?
The court ruled that an exact imitation is absolutely not necessary to commit the crime. The legal standard is whether there is a colorable resemblance calculated to deceive the common run of people.
Calculated to deceive. That implies intent.
Intent and execution. Let's say you go to a party supply store and buy a flimsy neon blue shirt with a plastic star pinned to it and the word Party Patrol stenciled on the back.
Sounds like a terrible costume.
It is. But even if you walk down a public street wearing it, no reasonable citizen, the common run of people, is going to be deceived into believing you are an actual agent of the Philippine National Police.
Because it looks fake.
Right. The resemblance is not calculated to deceive.
But if I go to a tailor...
If you go to a tailor, have a uniform cut from the exact same dark blue fabric used by the police, attach realistic-looking shoulder patches, pin on a convincing metal badge, and then walk into a crowded bank.
Then there's a problem.
The calculation is obvious. Even if the shade of blue is slightly off or the badge has the wrong city seal, the colorable resemblance is high enough that the average person in that bank will perceive you as law enforcement.
They won't look that closely.
Exactly. That is the exact public and improper use the law seeks to punish.
And the sources note this isn't just about government agents. It applies to religious classes as well.
Yes. The text points out that if a layman publicly and improperly dons the ecclesiastical habit of a Catholic priest and uses that visual authority to solicit donations from the public, they are fully liable under Article 179.
Oh, wow. They're usurping visual trust.
They are usurping the visual trust of a specific class. Furthermore, the legislature created a separate law, Republic Act 493, specifically to protect military authority.
What does that one do?
This act punishes wearing the insignia or rank of the armed forces or the national police. But importantly, this law contains explicit carve-outs.
Like what?
It exempts the use of these uniforms in a playhouse, theater, or moving films. The law protects the actor on a movie set, recognizing that the context is inherently theatrical and not calculated to deceive the public reality.
Okay, we have spent a significant amount of time building a massive, complex foundation here.
We really have.
We have explored the strict rules governing aliases from the 1930s. We've defined the boundaries of usurping authority and the psychology of uniforms. We have seen that the Philippine legal system creates a very narrow path for identity, with severe penal consequences for stepping out of bounds.
That's the landscape.
Which brings us finally to the absolute climax of our deep dive. What happens when all of these unbending rules, all of these strict statutes, crash head-on into the most powerful individual in the nation?
This is where theory meets raw reality. We are looking at the ultimate legal stress test.
We are. Now, before we lay out the facts of this event, I need to make a very explicit, very clear note to you, the listener.
Yes, this is important.
We are about to examine an immensely politically sensitive, historically seismic Supreme Court decision from 2009. The case is People of the Philippines versus Joseph Ejercito Estrada, docketed as GR Nos 16436869. Our mission in discussing this case is purely analytical. We're looking at this entirely through the lens of the provided legal source material. We are not here to take political sides.
Yeah.
We are not here to debate the legacy of the Estrada administration, nor are we here to litigate the history of that era. Our solitary goal is to observe the legal mechanics.
Just the mechanics.
We are examining exactly how the Supreme Court took the laws we just spent half an hour discussing Commonwealth Act 142 and the banking laws and applied them to a sitting president. We are impartial observers of the legal grammar.
And purely from the perspective of legal mechanics, this case is an absolute masterclass.
There really is.
It is a brilliant, cold dissection of statutory construction and a profound demonstration of the crushing burden of proof required in criminal law.
Okay, let's set the stage and look at the formal charges. It is April of 2001. Former President Joseph Estrada is facing a barrage of indictments.
A lot of charges.
There is an information, which is the formal charging document for the non-bailable offense of plunder. There is another information for perjury. But critically, for our deep dive, there is a separate specific information charging him with the illegal use of an alias.
And the prosecution's narrative in this specific information was highly detailed.
How detailed?
They alleged a very specific sequence of events occurring on a very specific date. They claimed that on February 4, 2000, while he was the active sitting president of the Republic, Estrada engaged in a financial transaction at Equitable PCI Bank.
Okay.
They alleged he opened a numbered trust account, specifically identified as Trust Account C163.
And the crux of the alias charge is the signature on the bank documents, right?
Exactly. The prosecution alleged that he did not sign his christened name. He did not sign his universally recognized screen name.
Right.
Instead, they charged that he executed these legal banking documents using the completely unauthorized alias Jose Velarde.
And returning to our earlier discussion of Article 178 and CA 142, the prosecution had to allege a purpose for this deception.
They did. The information explicitly stated that his purpose in using the Jose Velarde alias was to conceal ill-gotten wealth allegedly acquired during his tenure as chief executive.
And to actively conceal his true identity as the president in these massive financial transactions.
Yes.
Now, based on everything we learned in the first half of this discussion, this looks like the textbook definition of the crime.
It does on the surface.
He used a name that was never authorized by a court. He used it on an official legally binding document. And he allegedly did it for the express purpose of concealment.
Right.
But what makes this case so striking is that the prosecution didn't just rely on a paper trail. They didn't just have a suspicious signature analyzed by handwriting experts. They had eyewitnesses in the room.
They had what any prosecutor would consider star witnesses.
Who were they?
During the trial at the Sandigan-Bayan, which is the special appellate collegial court in the Philippines that has jurisdiction over criminal and civil cases involving graft by public officers, the people presented two high-ranking executives from Equitable PCI Bank.
Wow.
Clarissa Ocampo and Adamady. Manuel Curato.
And these weren't low-level tellers, these were senior officers.
Yes. And both Ocampo and Curato took the stand under oath and testified that they were physically present in the room on February 4, 2000. They testified that they personally watched the president open the trust account, and they watched his hand move across the paper as he signed the documents as Jose Velarde.
But the room wasn't just bank officers, right? The sources note 2 other individuals were present.
Correct. The prosecution established that also present in this private room during the signing were Aparicio Lacrin, who was serving as the president's chief of staff, and Fernando Chua, who is described in the records as a lawyer friend of the president.
Okay, let's tally this up. You have 4 living, breathing witnesses.
4 people in the room.
2 of them are bank officers who testify under oath that they watched the president sign a fake name to a legal document.
Mm-hmm.
If I am a layman sitting in the gallery of the Sandigan-Bayan, listening to this evidence unfold, I am immediately thinking, this case is airtight.
Right, you'd think so.
We just spent 30 minutes dissecting the sheer unyielding strictness of Commonwealth Act 142. We established you could face 6 months in jail just for informally going by Chip instead of Charles is on a contract without a court order. And here, the prosecution has 4 witnesses to the physical act of a president signing Jose Velarde to hide wealth. That sounds like an insurmountable slam dunk violation.
It sounds impossible to beat.
How on earth does a defense team even begin to respond to evidence that overwhelming?
Well, the defense responds by refusing to engage with the narrative entirely.
Right.
Instead, they clinically dismantle the legal structure of the prosecution's case. After the prosecution finished presenting all their witnesses and formally rested their case, the defense executed a brilliant and highly aggressive procedural maneuver.
What do they do?
They filed a demurrer to evidence.
Okay, I want to spend some time on this because a demurrer is such a powerful, almost arrogant legal tool. What exactly does filing a demurrer to evidence mean in a criminal trial?
It is the ultimate expression of legal confidence. When a defense attorney files a demurrer to evidence, they are essentially standing up and addressing the judges of the Sandigan Bayan and saying, "Your Honors, let us assume for the sake of argument that every single word the prosecution's witnesses just said is 100% true."
They concede the fact.
For the sake of argument, yes. They say, let us assume the signature is his. Let us assume he was in the room. Even if we accept all their evidence as absolute fact, their case still fails.
Why?
Because the evidence they presented is legally, structurally insufficient to prove the specific elements of the crime they chose to charge in the information.
Wow. It's a motion to dismiss the case immediately.
Yes. It asks the court to dismiss the case right then and there, without the defense having to call a single witness of their own, without having to present a single piece of paper in rebuttal.
That's incredibly risky.
It's a high wire act. You are telling the court that the state's math simply does not add up to a conviction. And depending on the procedural rules, if the court denies the demurrer, the defense might waive their right to present evidence entirely.
So you only file it if you are absolutely certain the prosecution missed a vital structural element of the law.
Absolutely certain.
And in this incredibly high-profile case, the Sandigan Bayan actually granted the demurrer.
They granted it. They dismissed the alias charge against the former president based purely on the insufficiency of the prosecution's evidence.
I can't believe it.
And when it was appealed, the Supreme Court upheld that dismissal. This ruling is a profound, unyielding reminder of the bedrock principles of criminal law.
Which are?
Penal laws are always, without exception, construed strictly against the state and liberally in favor of the accused.
The burden of proofs is just that heavy.
It is monumental. The prosecution must prove every single element of the specific crime charged beyond a reasonable doubt.
Did the president's status play into it?
Not at all. Critically, the Supreme Court explicitly noted in this decision that the law treats a sitting president exactly the same as an ordinary citizen on the street.
Really?
Yeah, the prosecution tried to argue a novel theory. They claimed that because Estrada was the president, the highest official in the land, he owed a higher special duty to the public to disclose his true name in all dealings.
So they wanted a different standard.
They wanted the standard of the law to be applied differently to him.
And the court said no.
The Supreme Court flatly rejected that argument. They stated that the law makes absolutely no distinction. The mode of violating Commonwealth Act 142 is exactly the same, whoever the accused may be.
No double standards.
There are no double standards in the Penal Code. The state must prove the same elements whether the defendant is a president or a plumber.
Okay, so we have to look at the mechanics here. How did this seemingly airtight case with 4 eyewitnesses structurally fall apart?
It's all in the details.
How do you lose a case when everyone agrees he signed the name?
The collapse of the prosecution of the case comes down to 2 fatal flaws.
So here's the first one.
The first flaw is rooted entirely in grammar. Specifically, the fatal grammatical choices made by the prosecution when drafting the indictment.
Grammar.
Yes. To understand this, we have to return to a case we mentioned earlier, the 1996 Supreme Court ruling in Ursua v. Court of Appeals.
Right. We brought up Ursua when discussing the 1930s Chinese merchant crisis. But what did the Ursua doctrine actually establish regarding how CA 142 operates in the modern era?
The Ursua decision provided the definitive, binding interpretation of the specific elements required to violate Commonwealth Act 142.
Which are?
The Supreme Court ruled that to be found guilty of the illegal use of an alias, it is absolutely not enough to simply use a fake name on one isolated occasion. The law requires that the alias must be used publicly, and it must be used habitually.
Habitually being the operative word.
Exactly. The court stated there must be a clear sign or indication that the user intends to be known by this alias, in addition to their real name, in their everyday dealings from that day forward. Remember the history. The law was targeting merchants who systematically adopted new identities to operate in the commercial sphere. It was not designed to punish a single isolated use of a pseudonym on a single day.
So single instances simply do not trigger the penal provisions of CA 142.
They do not.
Okay, so the legal burden on the prosecution is clear. They cannot just prove Estrada signed Jose Velarde once. They have to prove he used it habitually.
They have to prove a pattern.
Looking at the records, did they attempt to do that?
They certainly tried. During the trial, the prosecution introduced evidence beyond the initial February 4 signing.
What kind of evidence?
They presented various deposit slips from subsequent months, March, April, etc., showing continuous deposits into the Jose Velarde account. They were trying to build a timeline to show a habit.
Okay, that makes sense.
But this entire effort was completely obliterated by the exact wording they chose to use in their own charging document.
Let me pull up the exact quote from the information, the sources, because when I read this, I was stunned.
Go ahead, read it.
This is the formal charge sheet drafted by the best prosecutors in the country. It alleges that the accused committed the crime, and I quote, on or about 04 February 2000, or are sometime prior or subsequent thereto, end quote.
Or are. It all comes down to that word.
It's just a two-letter conjunction. How does that destroy a case?
It is a two-letter word that structurally dismantled a presidential indictment. Let's engage in a deep linguistic analysis of what that sentence actually means in a court of law.
Okay.
The prosecution utilized the disjunctive conjunction or are. They told the court the crime occurred on February 4, or sometime before, or sometime after.
Right.
By phrasing the timeline as a multiple-choice question of mutually exclusive dates, they legally limited the scope of the charge to a single, isolated occurrence.
I see, because or means you have to pick one.
Precisely. If I tell you that I went to the grocery store on Monday or Tuesday or Wednesday, I am communicating that I made exactly one trip and it happened on one of those 3 days.
You didn't go all 3 days?
I am not telling you I went on all 3 days.
Yeah.
If the prosecution had simply used the conjunctive and D, if they had drafted the charge to read on February 4 and D dates prior and subsequent to the two, they would have successfully alleged a continuous, unbroken pattern of habitual behavior spanning multiple months.
Oh, wow. I'm trying to visualize the prosecutor drafting this. I imagine they used or as a sort of lazy safety net.
Very likely.
Like a badly written restaurant menu where it says you can have the soup or the salad. But the prosecutor thought by writing or they were giving themselves the flexibility to just grab whatever evidence fit later on. They thought they were ordering both.
That is exactly the trap they fell into. They viewed or are as a procedural shield to protect their case against any minor variance in dates during the trial.
But the courts didn't buy it.
But the Sanigan Bayan and ultimately the Supreme Court refused to allow that intellectual shortcut. The courts said no. You cannot draft an indictment using the word or, which limits the charge to a single instance, and then show up to trial attempting to present evidence for a habitual, continuous pattern across several months.
But why are the courts so rigid about this? Why not just let them present the evidence?
Because allowing that would violate the deepest tenets of constitutional law.
How so?
The Bill of Rights guarantees that every accused person has the absolute, unassailable right to be informed of the exact nature and cause of the accusation against them. This isn't just paperwork. This is how a citizen prepares to fight the state for their liberty. The accused reads the information to understand exactly what they must defend against.
So if the information says you committed a crime on a single day, February 4, or some other day,
then you prepare your defense for a single day's event. You gather alibis for one day. You prepare arguments about the events of one specific meeting.
right?
If the prosecution then arrives at trial and suddenly attempts to bury you with evidence of financial transactions you allegedly made in March, May, and July, they are legally ambushing you.
You have no way to prepare.
You were never informed you were on trial for a months-long habitual pattern. Because of this constitutional violation, the court ruled that all the evidence from those subsequent months was inadmissible for proving the alias charge.
So all those deposit slips were thrown out.
Exactly. The only legally relevant evidence the court could consider was what happened in that room on that single day, February 4, 2000.
And if the court is legally restricted to evaluating only a single day?
Then it becomes mathematically and legally impossible to prove habitual use.
Wow.
As the Supreme Court noted, repeated use of an alias within a single day or even signing multiple documents during a single afternoon meeting cannot possibly be deemed habitual.
Right, it's just one event.
It does not amount to a customary practice or an established pattern of life. The element of habituality simply vanished.
I want to pause here and play devil's advocate for the listener because I can hear the frustration building.
Oh, I'm sure.
Someone listening to this is probably thinking, this is absurd. Shouldn't the Supreme Court look at the obvious intent?
Sure.
The prosecution clearly meant to charge a habitual crime. They had the deposit slips to prove it. They just made a clumsy grammatical error. isn't focusing on one conjunction, one tiny or, letting a massive blinding technicality defeat the pursuit of substantive justice?
That is the instinctive reaction, but if we step back and examine the philosophy of how a justice system must operate, we realize a profound truth. In criminal law, there are no mere technicalities. The rules of grammar in an indictment are the physical walls that protect a citizen's liberty from the awesome, otherwise unchecked power of the state.
They're a shield.
The precision of legal language is the only thing that ensures fairness. If we allow judges to casually rewrite indictments from the bench, if a judge can say, well, the state wrote or, but they obviously meant A and D, so we'll just let it slide to secure a conviction, we completely erode the rule of law.
Because then the rules are just arbitrary.
Exactly. And consider the implications. If the state can be sloppy and legally careless with a sitting president's indictment, a case backed by infinite state resources, unparalleled media scrutiny, and the most elite prosecutors in the republic.
They'll do it to anyone.
They will absolutely be sloppy with the indictment of a regular disenfranchised citizen who can't afford a lawyer. The Supreme Court's ruling is enforcing a universal standard. If the sovereign state wishes to strip away a citizen's liberty, it must draft its charges with absolute unforgiving precision. The state must bear the burden of its own errors, not the accused.
That is a deeply compelling point. Holding the state to the highest possible bar protects everyone else down the line.
That really does.
So the prosecution catastrophically failed the habitual test because of a grammatical error. But the Estrada doctrine required the use of the alias to be habitual and public.
Right.
Even if they couldn't prove habituality, could they at least salvage the case by proving the use of Jose Velarde in that room on February 4 was public?
This brings us to the second fatal flaw, and it pivots our deep dive directly into the incredibly secretive, heavily fortified world of Philippine banking laws.
The shield of privacy.
Exactly.
The prosecution's argument here seems pretty straightforward. They said he didn't do this alone in a closet. He signed the alias in a room with 4 other people.
2 bank executives and 2 associates.
Right. And doing something in front of an audience of 4 is not private. That is public use.
It sounds logical until you apply the statutory context. The Supreme Court didn't just count the bodies in the room. They looked at the legal nature of the location and the transaction taking place.
The bank account itself.
The accused was inside a bank, actively opening a trust account. The moment you introduce banking, you trigger the application of Republic Act No. 1405, the Secrecy of Bank Deposits Act.
Now, I saw in the sources that the prosecution tried a very technical workaround here. They argued that a trust account isn't technically a deposit in the traditional sense.
Yes, they did.
They tried to categorize it as an investment vehicle, arguing that, therefore, the bank's secrecy protections shouldn't apply to this transaction.
It was a clever attempt to exploit the complex creditor-debtor relationships of finance, but the Supreme Court immediately shot it down because the issue had already been settled in prior jurisprudence.
Which case?
A case called Estrada v. Sandigan-Bayan. The court looked at the fundamental philosophy behind RA 1405.
Why does the bank secrecy law exist to begin with?
The state explicitly created this law to encourage the populace to deposit their money in banking institutions rather than hoarding it privately.
For the economy.
Yes. This massive accumulation of capital within the banking system is what allows banks to lend money and drive national economic development. To incentivize people to trust the banks, the state offered an ironclad guarantee of absolute confidentiality.
So the state trades privacy for economic liquidity.
Exactly. And Section 2 of RA 1405 is incredibly broad. It protects all deposits of whatever nature. The Supreme Court ruled that this phrasing is expansive enough to cover trust accounts. Therefore, the account being opened on February 4 was of an absolutely legally confidential nature.
So applying this to the room, what does this mean for Ocampo and Curado, the 2 bank executives who watched him sign?
It means that Ocampo and Curado were not just casual observers. They were banking professionals bound by the massive legal weight of RA 1405.
They couldn't talk even if they wanted to.
They were legally sworn under threat of criminal penalty themselves to maintain absolute secrecy regarding the transaction and the identity of the depositor.
Wow.
The Supreme Court reasoned that signing a document in front of people who face prison time if they ever tell anyone what they saw is the exact polar opposite of public.
That makes total sense.
A communication covered by a statutory mandate of absolute confidentiality completely negates the concept of publicity. You cannot logically intend for a name to become public knowledge if you only use it in front of people who are legally gagged from speaking about it.
Okay, the logic holds for the bankers. Their silence is mandated by statute. But what about the other two men in the room?
Lacrian and Chua?
Right. Laquian, the chief of staffs, and Chua, the lawyer friend. They weren't employees of Equitable PCI Bank. They weren't bound by the Bank Secrecy Act. Doesn't the presence of two non-bankers destroy the expectation of privacy and make the act public?
The court meticulously examined their specific roles and relationships to the accused. Laquian was not just a random bystander, he was the president's chief of staff.
Which means?
This is an executive role that inherently involves sharing and protecting matters of the highest and strictest political and personal confidence.
Okay, and Chua?
Chua is described as a lawyer friend. The court recognized that he was bound both by his professional oath of office as a lawyer to protect client confidences and by deep ties of personal friendship.
So they were basically part of his inner circle.
Exactly. The court concluded that the presence of these specific individuals did not indicate any intention whatsoever by Estrada to be publicly known by the alias Jose Velarde.
He wasn't broadcasting it.
He wasn't broadcasting this new identity to the common run of people. He was utilizing it inside a locked room, surrounded exclusively by trusted, intimate confidants and sworn, legally silenced banking officials.
Right.
Because of this impenetrable bubble of confidentiality, the required element of public use under Commonwealth Act 142 was completely legally absent.
Wait, I need to look at the timeline again. Because anyone familiar with modern finance knows that the Philippines has very aggressive anti-money laundering laws today.
Oh, very aggressive.
The AMLA Republic Act number 9160. And I am almost certain that the AMLA explicitly and unequivocally bans the creation of anonymous accounts or accounts under fictitious names.
It does.
Didn't that law make the entire concept of the Jose Velarde account explicitly illegal?
It did. You are entirely correct about the modern law. The Anti-Money Laundering Act explicitly prohibits anonymous accounts and the use of fictitious names in banking.
Okay, so then.
But here is the inescapable chronological detail that governed this case. The transaction inside Equitable PCI Bank, where Estrada signed the documents as Jose Velarde, occurred on February 4th, 2000.
Right.
Republic Act 9160, the AMLA, was not passed by the legislature and enacted into law until 2001.
A year too late.
A year too late. And this brings us to one of the most fundamental protections in democratic jurisprudence, the absolute constitutional prohibition against ex post facto laws.
What does that mean practically?
An ex post facto law is a law that retroactively changes the legal consequences of actions that were committed before the enactment of the law. You cannot criminalize an act today and then punish someone for doing it yesterday when it was still technically illegal.
It prevents the state from constantly moving the goalposts to trap its citizens.
Precisely. It is a safeguard against tyranny. The reality is, prior to the passage of the AMLA in 2001, opening a numbered or anonymous trust account was actually a permitted, functioning banking practice in the Philippines.
Really?
Yes. It was regulated by various central bank circulars, but it was not explicitly outlawed by criminal statute in a manner that superseded the massive privacy protections of the Bank Secrecy Act.
That's wild.
The Supreme Court explicitly noted in its decision that the eventual passage of the AMLA in 2001 was essentially a legislative confession.
A confession of what?
It was the government acknowledging that a gaping hole previously existed in the financial laws, a loophole that allowed for the anonymous accumulation of wealth.
So, synthesizing all of this, what does this ultimately mean for the legacy of this case? Did the Bank Secrecy Act essentially function as a legally sanctioned get-out-of-jail-free card to shield illicit behavior?
That's a strong way to put it.
I mean, is the Supreme Court sending a message that as long as you conduct your crimes quietly inside a bank vault, the penal code regarding aliases doesn't apply to you?
That is the cynic's view, certainly, and it raises a profound question about how the judicial branch interacts with overlapping, sometimes contradictory statutes.
How do they address that?
During the appeals process, the prosecution furiously accused the Sanagan-Bayan of improperly harmonizing these different laws to artificially protect the accused.
Right.
But the Supreme Court forcefully clarified that they were not harmonizing conflicting laws because the laws were not actually in conflict. Each law operates perfectly within its own defined sphere.
Meaning they address entirely different behaviors.
Exactly. Commonwealth Act 142 is designed to punish the public, habitual, deceptive faking of a name in broader society. Republic Act 1405, conversely, creates a statutorily recognized impenetrable zone of privacy specifically around bank deposits to encourage economic growth. These aren't conflicting laws, they are parallel realities.
So they just happen to intersect in this one specific historical moment in that bank run.
Yes. When the accused utilized the alias entirely inside that statutory zone of privacy, the legally mandated privacy itself actively negated the publicity element required to trigger a violation of CA 142.
It's like a logic puzzle.
The court was exceptionally careful in its phrasing, and this is a vital distinction for the listener to internalize. The Supreme Court did not declare that the act of a president opening a secret numbered account to allegedly hide vast amounts of wealth was morally right.
They didn't endorse it.
They did not validate the ethics, the optics, or the integrity of the situation.
They were just looking at the math.
They were looking purely at the mechanics of the law. They ruled, coldly, objectively, and bound by the Constitution, that the state comprehensively failed to prove the specific legal elements of the specific crime they chose to charge.
The public and habitual use of an alias.
Exactly. Beyond a reasonable doubt. The evidence presented by the prosecution was fatally hindered by their own sloppy grammatical choices in the indictment and by the existing ironclad privacy laws that govern banking in the year 2000.
And the court has to follow that evidence.
The foundational rule of law dictates that if the state fails to discharge its monumental burden of proof, the court has no choice but to declare the accused not guilty of that specific charge. Justice is blind to the status of the accused, but it is hypersensitive to the text of the law.
That is an incredibly staggering mechanical breakdown of a legal battle. We have gone on quite an expansive journey over the course of this deep dive.
We covered a lot of ground today.
We really did. We started by exploring the bustling, confusing mercantile markets of Manila in the 1930s, unpacking a law originally designed to track the trade names of Chinese immigrants and protect the developing economy from chaos. We explored the intense psychological power of uniforms and the severe penal consequences for playing dress-up as a fake police officer or a stubborn city councilor refusing to leave office.
Yeah, that color of title doctrine.
And we ultimately ended up inside a highly confidential, locked bank room, watching a massive presidential legal battle get decided by the definition of a banking trust, the chronological date of money laundering laws, and the catastrophic placement of the two-letter word or are.
It's a lot to process. And ideally, by laying out this intricate web, we bring this entire abstract discussion back to you, the listener.
Exactly.
The goal is to illuminate how you navigate this invisible architecture every single day.
Yeah.
Your identity is not just the organic face you see in the mirror. It is a highly constructed, heavily regulated legal entity.
It's a license.
Every signature you put on a lease, every online handle you create for a new service, and every financial transaction you initiate sits right at the explosive intersection of your personal desire for privacy and the state's uncompromising demand for transparency and order.
It's a constant balancing act.
The laws we discussed today are not just dry historical footnotes. They are the active, aggressive boundaries dictating who you are legally allowed to be in modern society.
Absolutely. The tension never goes away. The battlefield just shifts. And I want to leave you with a final provocative thought to ponder on your own as we wrap up.
Okay.
We've seen throughout this deep dive how these laws governing identity are always reacting to the specific anxieties of their particular eras.
Like CA 142 in the 30s.
Right. Commonwealth Act 142 was a desperate reaction to 1930s commerce and immigration untraceability. Republic Act 10 was a harsh reaction to post-war sedition and shadow governments in the 1940s.
And AMLA for modern times.
Yes, Republic Act 9160, the AMLA, was a modern reaction to the terrifying scale of global money laundering in the 21st century. The law is perpetually playing a game of catch-up to human innovation and behavior.
It's always one step behind.
Always. So as we plunge deeper and faster into the digital age, an age where anonymous digital avatars, decentralized cryptocurrency wallets, and absolute online pseudonymity aren't just rare exceptions, but the standard operating norm for millions of people worldwide.
Where are we going with this?
Are our current legal definitions of public and private completely obsolete? If the Supreme Court ruled that a fake name used in a closed physical bank office with sworn officers isn't public, what happens when you use a fake name in a private, end-to-end encrypted chat room that happens to be hosted on a massive, publicly accessible server?
That's a great question.
Is that public? Is a Discord server a recognized zone of privacy? As the boundaries between our physical, flesh and blood identities and our sprawling digital footprints blur into entirely new, untested, legal, muddy waters, you have to ask yourself, in the 21st century, who truly owns your digital alias? Is it you? Or is it just another license waiting to be regulated, restricted, and punished by the state?
It is the next great legal frontier. The mirror is shattering all over again, and the courts are going to have to figure out how to put the pieces back together.
It really is. Thank you for joining us on this exploration. Keep questioning the boundaries, and we'll see you on the next deep dive.
Welcome to the debate. Imagine a locked room. Inside a bank, 4 people are standing around a table. A man signs a document with a name that is not his own.
Right, and the question is that a public act of deception or, the ultimate exercise of guaranteed privacy?
Exactly. It depends entirely on whether that locked door is protecting a legitimate secret or actively hiding a crime. Today we are examining the intricate legal boundaries between financial privacy and the illegal use of fictitious names.
Yes, specifically, we are focusing on the landmarked 2009 Supreme Court of the Philippines case, People v. Joseph Ejercito Estrada.
The central question we have to grapple with today is this. Does the statutory guarantee of privacy in a banking transaction legally negate the public and habitual elements required to convict an individual of illegally using an alias?
Anti-alias law, and Republic Act No. 4005, the Secrecy of Bank Deposits Act.
Not to mention Article 178 of the Revised Penal Code, and, the specific factual record of the Estrada case regarding the opening of trust account C-16-3.
Right, so I will argue that allowing the bank secrecy law to shield the explicit use of a false name, in this case Jose Velarde, in front of multiple witnesses, fundamentally frustrates the purpose of the anti-alias law. It creates an unwarranted loophole for concealing identity.
And I will argue that strict adherence to penal statutes and the established Ursua doctrine correctly dictates that signing a confidential bank document is a protected zone of privacy. It fundamentally lacks the requisite public and habitual intent to constitute a crime.
Okay, let's lay our cards on the table then.
Yes, when we approach penal laws, precision is not just a preference, it is a constitutional imperative. The anti-alias law, Commonwealth Act No. 142, was enacted back in 1936.
But we can't read it in a vacuum.
Exactly. We read it through the lens of the Supreme Court's historical Ursua ruling. Now, if you're listening to this and wondering why on earth a bank vault exempts you from the penal code, you have to understand the origin of this doctrine.
Which is fascinating, by the way.
It is. In 1936, the law was originally enacted to curb the practice among Chinese immigrants of using scores of different names in trade. That practice was creating tremendous confusion in the business world.
Right. The intent was to stop business fraud.
Precisely. That is the why behind the law. Because of that history, the Ursua doctrine established that to be convicted of using an alias, you must use it publicly and habitually.
With a manifest intent to be known by that name from that day forth.
Yes, you have to hold yourself out to the world under that false identity. Now fast forward to the Estrada case. When an individual opens a numbered trust account, like account C-163, under Republic Act 1405, that act inherently carries a statutorily guaranteed expectation of privacy.
Sure, but
let me just finish the thought. Confidentiality and secrecy are the exact opposite of publicity. Therefore, signing as Jose Velarde inside a bank vault cannot legally constitute a public use. It doesn't matter if the individual holds the highest public office in the land. The law must apply equally.
I come at it from a very different way. We have to question the foundational assumption that banking privacy equates to a blanket license for identity concealment.
I wouldn't call it a blanket license. When Joseph Estrada signed that document as Jose Velarde, he did not do it alone in a dark, empty room. He presented himself as Velarde in the physical presence of 2 bank officials, Clarissa Ocampo and Manuel Corrado,
Who were bound by banking secrecy.
and crucially, 2 non-bank associates, his chief of staff, Aprodisio Lakian, and his lawyer friend, Fernando Chua. That is 4 witnesses to a false representation.
But those witnesses...
Let me just finish the point here, because the physical reality really matters. Commonwealth Act 142 contains absolutely no explicit exception for banking transactions. None at all.
Okay, but RA 1405,
By forcing the anti-alias law to bow to the bank secrecy law, we are dangerously transforming a statute meant to encourage economic investment into a state-sanctioned firewall. The bank secrecy law is meant to protect your money from nosy competitors or kidnappers.
Which it did.
But the court allowed Estrada to use that same firewall to block the state from seeing a forged signature. We are allowing it to shield illicit activities under pseudonyms. That stretches the concept of a zone of privacy far beyond its logical or legislative intent.
I see why you think that, but let me give you a different perspective. Think of a conversation in a lawyer's office or a medical clinic.
Okay. Just because there is a nurse or a paralegal in the room doesn't transform a privileged, confidential disclosure into a public broadcast. The bank is a statutory vault of privacy.
A vault? Sure.
The Ursua doctrine is very strict. It requires that the user must hold themselves out to be publicly known by that name.
Wait, hold on. Are you saying that because his chief of staff was in the room, it legally didn't count as the public? How does his job title erase his status as a witness? Because the Supreme Court correctly analyzed the specific relationships in that room. It's not about erasing them as witnesses. It's about defining the nature of the space.
I mean, they were literally standing right there.
Yes, but the two bank officials, Ocampo and Corrado, are explicitly sworn to secrecy under RA 1405. If they speak, they go to jail, so they aren't the public.
And the other two?
What about Lakian and Chawla? The text is clear on this. Lakian was the chief of staff, handling matters of the highest state confidence. Chawla was a lawyer friend, bound by his oath and ties of friendship.
Oh, come on.
Their presence did not breach the zone of privacy because they were inside a closed circle of trust. They were fundamentally not representing the outside world.
I'm sorry, but I just don't buy that. Let me tell you why. You are equating a medical diagnosis where you are telling the truth to a doctor to get help with the act of assuming a false identity on a legal document.
The principle of the closed room is the same?
Look at Article 178 of the Revised Penal Code. It specifically penalizes using a fictitious name to conceal a crime, evade a judgment, or cause damage to public interest.
But he wasn't doing it publicly.
The bank secrecy law was passed to encourage people to put money into banks instead of hiding it under their mattresses so the banks could loan it out for economic development. It was never intended by the legislature to silence officials from reporting crimes.
The Supreme Court disagreed.
Ian and Chua were in a circle of trust. You are effectively arguing that as long as you only commit a crime in front of your closest, most loyal allies, it's not a public act. That logic neuters the anti-alias law entirely.
But you are presupposing the act as a crime before proving the mandatory elements of the crime. The law requires the act to be public.
It was.
The Supreme Court in 2009 explicitly stated that the statutorily guaranteed privacy and secrecy of RA 1405 effectively negate a conclusion that the transaction was done publicly. Estrada had a reasonable, legally backed expectation of privacy when he signed that form.
An expectation of privacy is one thing. Using an alias to bypass the very transparency required of public officials is another.
That's a moral argument, not a legal one.
But let's accept your premise for a moment. Even if we pretend those four people constituted a perfectly sealed private vault and not the public, you still don't have a clean defense.
Why not?
Because to violate the Ursua Standard, the use of the alias must be public and habitual.
Exactly. Habituality is the second mandatory pillar. If you don't have habituality, the entire charge collapses, regardless of who was in the room.
And it was habitual. Let's examine the text of the amended information. For the listener, the information is the formal charging document the state uses to officially accuse someone of a crime.
Right, the indictment.
It accused Estrada of using the alias, quote, in several transactions, unquote, and doing so on or about 04 February 2000, or sometime prior or subsequent thereto.
And that phrasing is exactly where the prosecution failed.
The prosecution presented evidence of multiple deposits into this account over several months. To take the phrase several transactions and shrink it down into a single isolated instance on a single day is a strained, almost absurd way to read a legal document.
I have to stop you there.
The information clearly intended to capture a pattern of behavior spanning months.
That's an interesting point, though. I would frame it very differently. The court didn't shrink anything. I mean, it read the plain, literal text of a poorly drafted legal document.
Poorly drafted?
Yes. In penal law, the state holds the absolute burden of clarity. Look at the specific wording you just quoted from the prosecution's own document. On or about 04 February 2000 or sometime prior thereto.
Right.
The prosecution used the disjunctive word or. Combine that with thereto, which grammatically refers back to February 4.
You're telling me a massive anti-graft case crumbled over a grammatical conjunction?
Words mean things in a court of law.
They were trying to cover the approximate timeline. That's standard practice under the rules of court when the precise date isn't a material ingredient of the offense.
Yes, and I will defend that strict reading because that conjunction is the bedrock of due process. Let me explain the mechanism here. The primary reader of an information is the accused.
Sure.
If I charge you with robbing a bank on a Tuesday, you prepare your defense by bringing witnesses to prove you are in Paris on that Tuesday.
Obviously.
If the judge then says at trial, well, the state says maybe it was Wednesday or maybe last month, your defense is entirely useless. The state has to be precise so the accused can defend themselves.
But the phrase was several transactions.
Is the prosecution meant to charge Estrada with using the alias on multiple distinct days over a period of months? They should have used the word and. They didn't.
Because they use standard boilerplate language.
Boilerplate or not, words have legal consequences. Because they used or, the strict legal reading limits the scope to a single day or an alternative single day.
That is just semantics.
And here's the mechanism that completely dismantles the habituality argument. Multiple uses of an alias within a single day cannot establish a customary practice. If I sign a stack of 20 papers on a Tuesday, that is one event. Therefore, the element of habituality completely fails.
That is an incredibly rigid reading. You are taking months of bank deposits and squashing them into a single day just because of a stylistic choice in drafting.
It's a legal choice.
It overrides the substantive reality that multiple transactions occurred under this fake name. The prosecution literally brought in the branch manager, who testified about 12 different deposit dates between October 1999 and July 2000.
But the Sandigan-Bayon, the anti-graft court, correctly ruled that those acts weren't covered by the indictment.
How?
The phrase in the information said he represented himself as Jose Velarde in signing documents with Equitable PCI Bank and/or other corporate entities. The deposits made by other people, like Baby or Taliza, don't fall under the specific acts charged against Estrada himself on that specific date.
You're ignoring the broader pattern.
You cannot try a man for acts not clearly stated in the information. It's not a technicality, it's the shield that protects every citizen from a state that can't get its story straight.
Which brings us to the deeper structural issue of how these laws interact in the real world. The failure to prove habituality and publicity here, largely due to this highly restrictive framing of banking and penal laws, forces us to ask a difficult question.
Which is,
how do we harmonize conflicting statutes without the court effectively rewriting the law?
Well, the Supreme Court noted they weren't harmonizing so much as recognizing where the laws interface.
But look at the massive incongruence they created at that interface. They treated trust accounts like C-163 as deposits under RA 1405.
Because they function similarly.
Now, for those unfamiliar, why does that distinction matter? When you put money in a standard savings account, the bank is essentially borrowing it from you. They owe you that money.
Right. Standard banking.
That's a strict creditor-debtor relationship, and that is what the bank secrecy law was written to protect. But with a trust account, the bank isn't borrowing your money. They are acting as your agent, taking your funds to invest them on your behalf.
It's a different financial mechanism, yes.
Exactly. And the court stretched the definition of deposit to cover trusts, specifically to extend a privacy shield over an act that the anti-alias law strictly prohibits.
I wouldn't say stretched.
And we know definitively that this was a massive loophole, because look at what happened next. The legislature had to step in shortly after this and pass RA 9160.
The Anti-Money Laundering Act?
Yes, AMLA. AMLA explicitly outlawed anonymous accounts and accounts under fictitious names. That passage is the smoking gun. It proves that these accounts were always a gaping hole that facilitated fraud. The court shouldn't have protected it by bridging the gap between a trust and a deposit.
I'm not convinced by that line of reasoning because you are applying a modern standard to past behavior.
How so?
You cannot apply the absolute prohibitions of RA 9160, the Anti-Money Laundering Act, to an event that occurred in the year 2000. Doing so violates the absolute constitutional ban on ex post facto laws.
I'm not saying charge him under AMLA.
But you're using AMLA's logic. You can't make something illegal today and arrest someone for doing it yesterday. At the time trust account C-16-3 was opened, numbered accounts were perfectly valid, legally recognized banking conventions.
Valid banking conventions, perhaps, but not exemptions from the Penal Code.
But you can't decouple them. The Secrecy of Deposits Act broadly covers deposits of whatever nature to prevent private hoarding. The court reasoned that a trust account qualifies under the spirit of encouraging wealth to enter the banking system.
Even if it's illicit wealth?
Therefore, the privacy attaches. You cannot penalize a citizen, even a president, for utilizing a loophole that the legislature had not yet closed. The fact that the Banco Central in the Philippines had to issue a circular in 2000 and Congress had to pass AMLA in 2001 is a tacit admission by the state that the behavior was not explicitly illegal beforehand.
That's a compelling argument, but have you considered that Commonwealth Act 142 was already on the books? It was passed in 1936.
Yes, we discussed that.
The state didn't need AMLA to make using a false name illegal. The anti-alias law already did that. The problem is that the court allowed the bank secrecy law to act as an overriding force.
It's an intersection of laws.
RA 1405 tells bank employees they can't talk. It tells the tellers and the branch managers to keep their mouths shut. It does not tell depositors they are magically immune from the penal code when they knowingly lie on a form.
That's quite a leap.
The court conflated the bank's duty of secrecy with the depositor's license to deceive.
Well, that relies on the premise that signing the form was a public act of deception. We circle back to Ursua. Remember the 1936 origin of the anti-alias law.
Business fraud.
Right. It requires a sign or indication that the user intends to be known by this name, in addition to his real name from that day forth. If you are signing a strictly confidential banking document, which the bank is legally forbidden from sharing under threat of imprisonment, you carry zero intent to be publicly known by that name.
Which is exactly why it's so frustrating. The intent was concealment, which is exactly what Article 178 of the Revised Penal Code targets. It penalizes using a fictitious name to conceal a crime.
But look at the text of Article 178.
I am. Notice the wording. It doesn't say you have to conceal a crime publicly. It says you cannot publicly use a fictitious name for the purpose of concealing a crime.
Yes, publicly use.
The use in front of 4 people was the overt real-world act. The purpose was the concealment.
But again, 4 people bound by legal and professional confidentiality do not constitute the public. The Supreme Court was rigorous here. They looked at the elements of the crime, they looked at the evidence presented, and they held that the prosecution simply failed to discharge its burden of proof.
They failed because the court narrowed the timeline based on the word or, and then narrowed the definition of public based on a highly generous, almost naive, interpretation of friendship and staff relations.
Generous? I'd call it legally precise.
It's a masterclass in how powerful people use procedural rules to escape substantive justice.
I disagree with the characterization of it as an escape. It is the uncompromising application of the rule of law. Let me summarize my position here.
Go ahead.
The rule of law demands strict construction of penal statutes. Under the Ursua framework and the statutory protections of RA 1405, the evidence simply did not prove beyond a reasonable doubt that the alias was used publicly and habitually.
Okay.
If the information is poorly drafted by the prosecution, the state must bear that cost, not the accused. Protecting civil liberties and the constitutional rights of the accused means accepting that sometimes legal privacy supersedes moral outrage.
And to summarize my position, while the technical letter of the bank secrecy law was upheld by the court, allowing a public official to sign a fictitious name to a trust document in the physical presence of multiple others stretches the concept of a zone of privacy far beyond its logical intent.
We definitely view that zone differently.
It effectively neutered the anti-alias law. The court allowed a law designed to boost the economy by getting money into banks to become a firewall for identity concealment, validating a loophole that shouldn't have required a new money laundering law to close.
We clearly have a continued disagreement on whether RA 1405 should be allowed to tangentially interface with and effectively neutralize Commonwealth Act 142 in these specific scenarios.
We do, and I think it reflects the immense value of studying this intersection of laws. It forces society to constantly evaluate the balance between the economic necessity of financial privacy and the public's interest in transparent identity.
How far does the vault door extend?
Exactly.
Absolutely. We encourage you, the listener, to explore the complexities of this statutory harmonization in your own reading of the material. Look at the exact wording of the information, look at the history of the Ursua doctrine, and decide for yourself how these laws should balance.
The ultimate conclusion on how these texts interact is up to you.
Think back to that locked room inside the bank. 4 people, a false name, and a signature. Is that a public act of deception or a statutorily protected secret?